show you what's been marked, I believe, as a full exhibit, 32. Can I grab the court's file? And the court's copy. I would represent to you that this is an excerpt from the transcript of Owen's trial. I would ask you to take a look, starting at line 13 on the first page. And let me know when you're ready to discuss, please.
I'm sorry, where was I supposed to end? Was I supposed to read the whole thing?
I would point you to page 25. You start at approximately line 8 and read to the bottom of that page.
I'm sorry, page 825?
Yes, page 825.
Yes, I've read it.
Thank you. So on page 822, Attorney Carney, after the state indicates that it's rests, the judge asks if there would be any motions by the defense. Attorney Carney goes on to say, if the government can rest, then we'll know. We know of one that we're bringing. That may be the only one. Is that a fair summary?
I believe that's what he says, yes. Or that's what the transcript says, yes.
Then on page 25, the court says, go ahead, I understand the state has rested, you wish to proffer a motion. Attorney Carney says, I move for motion of entry of not guilty on the charge involving the prefect.
That's correct.
That was his motion for directed verdict.
I don't specifically recall that, but that's an accurate reading of the transcript, yes.
He moved for directed verdict on one charge.
Again, that's what the transcript says.
How many charges do you recall Owen having?
I think 10.
He didn't move for directed verdict on any of the felony sexual assault charges.
All I have before me is the transcript. I don't recall.
He did not move, based on the transcript that you've reviewed, for directed verdict on the misdemeanors.
That's correct.
The misdemeanor sexual assault or the misdemeanor endangering, correct?
That's correct. That's what's represented in the transcript, yes.
And certainly not the computer charge.
That's correct.
Do you recall that Owen was not even in the courtroom at that point?
I believe that's correct. I actually don't think I was in the courtroom at that point.
Okay. You waived Owen's presence in the courtroom?
I didn't.
Did you discuss with Owen that you were going to waive his presence?
I don't remember.
Is that something typically you would discuss with a client?
Me, I would, yes.
And by not moving to dismiss on the other charges, you failed to preserve issues for appeal.
Excuse me?
You failed to preserve issues for appeal.
Is that a question?
It is.
Is the question, did we?
I guess the question is, do you agree with the statement that by failing to move for directed verdict on all charges that you waived certain appellate issues?
I didn't. I didn't handle that. So if you're asking if I waived it, I didn't. If you're asking, yeah.
I'm sorry. You were part of the trial team.
I was, yes.
You were co-counsel in this case.
That is correct.
Fair to say that you were aware of what was happening in this case.
Generally, yes, of course.
And you were responsible for what happened in this courtroom when Owen was on trial.
I agree with that, yes.
You are responsible for the fact that you failed to move for directed verdict at halftime.
Is that a question?
It is a question.
What is the question?
Are you responsible for failing to preserve issues for appeal?
If we failed to preserve the issues, yes, I think the whole trial team, myself, Attorney Carney, and Attorney Rancourt would be responsible for that.
Is that effective?
Excuse me?
Is that effective representation?
If we didn't preserve an issue for appeal, that's obviously not ideal representation.
Not ideal. Is it ineffective?
I think that's for a court to determine.
And as Judge Smuggler ruled in his order on your motion to set aside the verdict, you filed too late when you filed that motion to set aside the verdict.
He ruled that it was untimely, yes.
You also said on direct that the terms in the computer statute were probably intentionally broad and fairly vague, and didn't think there was any question that the allegations here, if true, would qualify. Do you remember that statement?
Yeah, I mean, I don't remember word for word, but it sounds like what I said.
You don't have any specific recollection of legal research that you conducted?
I remember looking at the statute. I remember looking at case law. I can't tell you specifically what cases I looked at or even the specific issues, but I do remember doing case law in connection, doing legal research in connection with the trial in this case.
You did no legal research into how the SPS email system or internet system worked?
That's correct.
Did you read Farrington?
I don't recall.
You don't recall the details of Farrington?
A year and a half later, no, I don't.
The New Hampshire Supreme Court has specifically delineated a difference between communications that are online and offline. Do you remember reading them?
I remember the case name. I think it was referenced, or it sounds familiar to me. Do I have a specific memory of a case that I read a year and a half ago? I don't.
In fact, in Farrington, the court noted that the interconnected nature of online communications allows the predator to contact more potential victims and to make initial contacts more insidiously than would be possible offline. Do you remember that statement?
As I said, I don't have a specific recollection of what's in the case.
Fair reading of that is that if a communication was not online, there may be a question of whether it fell under the statute.
I think that's a possible argument based on the portion you just read to me.
Did you investigate what online meant for purposes of Owen's trial?
We looked at the facts and the allegations and considered whether it applied under the statute. I'm not sure what you mean by investigate.
Did you do any research specifically on what the term online meant?
I'm not sure.
Did you do any research specifically on what internet meant?
I'm not sure.
Did you do any research specifically on whether intranet would qualify?
Not that I recall.
And it's fair to say that if emails were relied upon, and we don't really know that because you didn't move for a bill of particulars, correct?
We did not move for a bill of particulars.
And I believe you said yesterday that you don't know which communication was relied upon for the conviction, correct?
Correct. My view is that it was always sort of one course of communication, but that's correct.
Fair to say, though, that if the emails were relied upon and those were sent via the SPS intranet, and if that intranet did not access the internet, that those may not fit under the statute.
I mean, I think that's a question for the judge. I think it probably would have been a factual question that would have gone to the jury, but there's an argument there, I suppose.
But you didn't raise it.
We did not know.
And in this case, it's not obvious
What?
that something sent on an intranet would qualify under that statute.
Like I said, it's an argument you can make.
If the two communications had been sent by cell phone, one by text message and one by messenger on a computer, would you have requested a bill of particulars then?
Could you say that again?
Sure. Do you use an iPhone?
I do.
Do you use a Macintosh computer?
I do.
Are you familiar with what iMessenger is?
Yes. Text messages, essentially?
Yes.
Yeah, I am.
Do you text from your phone?
I do.
Do you text from your computer?
Sometimes.
So under this statute, would those communications be treated the same?
Off the top of my head, I don't know. I think it depends on whether you're accessing an internet service, an online service, and I think there's a third category. But off the top of my head, I'm not sure.
It depends on if you're accessing an internet service. Is that what you just said?
That's one of the systems that's set forth in the statute.
Think it would have been a good idea to maybe at least investigate how the communications presented by the state were transmitted?
A good idea. I mean, further investigation never hurts, but I generally didn't think there was any real question that Facebook messages and emails would qualify under the statute.
But there is a question here about whether that communication went online. Do you acknowledge that?
It's been raised, yes.
And the capability of the network to go online isn't the point here, is it? The point is how the communication that Owen sent was sent and whether that went on online.
I'm actually not sure if I read the statute that way, but I don't have it in front of me. My memory of the statute is that it focuses on the system that's used, not on the particular sort of travel route of the communication. But again, I don't have the statute in front of me.
After the trial, you started discussing a motion to set aside verdict?
Correct.
and you filed a motion to extend time to set aside that verdict. Do you recall that?
Yes.
Are you familiar with that document at this moment?
I mean, I recall it. I don't remember it word for word, but I remember the motion. I believe it was assented to by the state.
Would you like to review it?
If you'd like me to, I will.
I am going to question you about it, but would you care to review it before I do that?
Sure. Thank you.
May I approach Judge?
Sure.
I've reviewed it. Thank you.
That was filed the day before the deadline for the motion to set aside verdict. Do you recall that?
I don't, but I don't dispute it.
And in that motion, you said that you needed additional time to, quote, investigate whether the felony conviction may stand under these circumstances. That's in paragraph 4.
I think that's correct.
What circumstances were those?
Where he'd been acquitted of the aggravated felonious sexual assault charges and, when he was acquitted of the felony sex offense charges, but convicted of the misdemeanor sexual assault.
Did you not contemplate that possibility before trial?
We had thought about it, but obviously it was one of any number of possibilities, so it's not something we focused on exclusively.
This issue was not ripe prior to trial because the defendant could not have known that he would be convicted of the felony computer charge but acquitted of all sex offenses. That's something else that you wrote in your motion.
That's correct.
Why was it not ripe?
In my view, again, you had 10 indictments, and you have no way of knowing, what permutation is going to come down, whether he's going to be convicted of all 10, acquitted of all 10, convicted of 5, acquitted of 5. So the reality is, practical limitations being what they are, you don't have a chance to look at every single permutation ahead of time to, plan for that contingency, I guess.
It's I would suggest that it's fairly obvious that he could have been found not guilty of the felonies. In fact, that was your hope.
Is that a question?
That is a question.
What is the question?
It was your hope that he would not be convicted of the felonies.
Of course.
Of the felony sex assaults.
Of course. It was our hope that he would be acquitted of everything.
So it was foreseeable, though, that he would be convicted of the computer charge and not convicted of the felony sex assaults.
It was a possibility, of course.
This appears to be a novel issue in New Hampshire. What was novel about Owen being convicted of the misdemeanors and the felony computer charge, but not the felony sex assaults?
Again, this is a while ago, but my recollection is that there was not a case in New Hampshire that said that this particular computer charge offense could stand under these circumstances.
Did you think he could not be convicted of the computer charge if he was found not guilty of the felony sexual assaults?
No. I knew that he could be convicted of the computer charge based on the misdemeanor sex offenses.
Then I don't understand the statement that you made prior to that. Can you explain that to me, please?
Explain what?
Your statement was that you were unaware of a New Hampshire case, and I'm paraphrasing here, in which a defendant had been found not guilty of the felony sex assaults, and that a conviction for the computer services charge would rest with a misdemeanor sexual assault conviction.
Okay.
How does that line up with the fact that you said that you realized that these could stand?
I'm not sure I understand the last part of your question.
I can move on. Have you reviewed 649B4, the computer statute, recently?
Not recently, probably not since last year would be my best guess.
Okay. Certain use of computer services prohibited. Provision 1. No person shall knowingly utilize a computer online service, internet service, or local bulletin board service to seduce, solicit, lure, or entice a child or another person believed by the person to be a child to commit any of the following. And then it goes on to specify a couple of specific provisions, one of which is RSA 632A, the sex assault statute, the misdemeanor sexual assault statute, and the endangering of the welfare of a child as defined in 639.3, which is the misdemeanor endangering statute. Did you read State v. Moscone?
Honestly, I can't tell you yes or no, so long ago. Sounds familiar, but that doesn't mean much.
Quote, thus the crime is complete when the defendant uses the internet in an effort to solicit a child or a person believed to be a child to engage in sexual activity. It is the conduct of attempting or trying to seduce or solicit that the legislature is prohibiting. So 649B4 does not require sexual contact.
Are you asking me?
I am asking.
My understanding is that the computer charge...
Would you like to review the statute?
No, I'd like you to rephrase the question. I'm not sure I caught it.
Sure. State v. Moscone includes the following. Thus, the crime is complete when the defendant uses the internet in an effort to solicit a child or a person believed to be a child to engage in sexual activity. It is the conduct of attempting or trying to seduce or solicit that the legislature is prohibiting. So that statute, that case, interprets 649B4, which is the computer charge. That statute doesn't require the culmination of sexual contact.
I believe that's correct. That would be my reading of the statute.
It doesn't require any contact.
That's correct. The crime occurs when the message is sent.
It doesn't require that the person sending the communication ever actually meet the recipient.
That is correct.
The offense is complete as soon as the communication is sent.
That is correct.
So explain to me how it's novel, in your mind, that the computer charge could not stand when he was found not guilty of the felony sexual assaults and found guilty only of the misdemeanor sexual assaults.
The arguments we raised in the motion to set aside verdict were twofold. One was that the result in this case, in the sort of unique facts of this case, was that the result, particularly the fact that he'd have to register as a sex offender for life, was inconsistent with the overall statutory scheme or purpose. The second argument was the Eighth Amendment challenge, which I think fairly clearly can't be raised until punishment is at least imminent. So those were the two. And I guess with respect to the question of why it was novel, the argument was based on the facts and I think unique circumstances in this case. Specifically the sex offender registration.
That doesn't explain to me why you thought the conviction on the computer charge could not stand if he was found guilty only of the misdemeanors.
I didn't say it could not stand. I said we made an argument that the judge had discretion to set it aside. The statute applies to misdemeanor sexual assault. I understand that. But we made an argument that the judge had discretion to set aside the verdict.
I would refer you back to paragraph 4 of your motion to extend, which states that you've had to investigate whether the felony conviction may stand under these circumstances.
Correct.
I presume that you did some research between the time that you filed the motion to extend the deadline and when you filed the actual motion to set aside.
I think someone in my office probably did, but I don't have a specific memory of it.
Well, I think you testified yesterday that you did legal research.
I think again, I'm not sure, but I thought I testified yesterday that we hadn't done the research into the legislative history, but I thought that we might have done research into the case law. But again, I'm not sure.
Well, I showed you yesterday a screenshot of the research folder.
Correct.
And you saw no evidence in that folder of legal research on the computer offense.
That's correct.
said that you may have done some research, but you wouldn't have saved it there because you frequently work from home.
I mean, I didn't say I wouldn't have saved it there, but there were instances.
I apologize.
Yeah.
You may not have saved it there.
There were instances where I'd be working from home where I wouldn't necessarily save things. And we filed a motion on those issues, so clearly we did some legal research at some point.
Judge, can I have just 1 second?
Yes.
Have you had the opportunity to review the motion that you filed to set aside the verdict?
Yes. Excuse me.
Well, I think what I presented you there was the motion to extend.
Oh, I'm sorry. Have I had a chance to review the motion to set aside the verdict?
Yes.
Not in some time,
Okay.
but obviously back then I did.
Did you review anything before you came in today or yesterday to testify?
I reviewed my interrogatories. That's really it over the last week. I read Attorney Carney's interrogatories at one point, probably some time back, and I skimmed Attorney Rancourt's. I don't think I ever read them too thoroughly. And when I was preparing the interrogatories, I went through old emails and things of that nature. Excuse me.
So on October 13th, 2015, Danya did a memo on timeliness research. Do you recall that?
Vaguely, yes.
May I approach the witness, Judge?
Yes.
Thank you. Showing you what's been marked as a full exhibit number 9. Just ask that you take a look at that and let me know when you're prepared to discuss.
I've read it.
This memo was drafted because the state's response accused you of filing an untimely pleading, correct?
I don't remember that, but that makes sense.
And you ended up having to do a response to the state's pleading,
I believe we did, yes.
basically trying to save your motion to set aside verdict.
We argued that it was timely, yes.
And that's what this memo was for.
Yeah, I think so.
And that memo was incorporated into the pleading.
It may have been, I don't know.
But you wrote the motion to set aside the verdict.
I believe I was the primary author, yeah. I wrote it. And I think there were probably edits and input and things like that, but yes, I was the main writer,
Okay.
I think.
And the arguments that you raised in the motion to extend basically continue into the motion to set aside the verdict. Do you recall that?
Could you say that again?
The arguments that you initially raised in the motion to extend carry over and into the motion to set aside verdict, correct?
I don't know.
Okay, well, let's talk about that for a moment.
Yeah.
Paragraph 7 of your motion, the consequence...
Which motion?
Sorry, this is the motion to set aside. I can provide you with a copy.
It's up to you.
May I approach the witness, Judge?
Yes.
Were you referring me to paragraph 7?
I believe. I started at page 4, paragraph 7.
Yep, I have it here.
Okay. The consequences of the felony conviction for the defendant are enormous. This conviction increases his potential sentence exposure by 7 years and gives rise to the possibility of a state prison term. Even more devastating is that his conviction for the computer felony mandates lifetime sex offender registration. Were you aware of that mandated lifetime sex offender registration before trial?
No.
You were not?
I became aware of that at some point during the trial.
Oh. So you didn't realize that that lifetime registration was a potentially more damaging or equally damaging penalty as the potential incarceration?
I mean, as far as placing values on it, I didn't look at the sex offender registration questions until later in the trial. I recall that.
The maximum, I'm referring to paragraph 8 now.
Mm-hmm.
The maximum penalty for a single count of sexual assault under RSA 632A4 is 1 year in the House of Corrections. The RSA 649B4 carries a maximum penalty of 7 years in the state prison. It is dubious that the legislature intended to increase the penalty 7-fold simply because the offender used a computer in furtherance of the underlying misdemeanor offense. Sorry, 1 second. It is apparent from the overall structure of the criminal code that certain use of computer services prohibited is a felony precisely because it is presumed to be a prelude to an aggravated felonious sexual assault or some other felony sexual assault. Were it intended to apply in cases of misdemeanor sexual assault, there is no rational reason that the legislature would have created such disparate sentencing caps for the two offenses.
That's what it says, yes?
You're aware that RSA 649B4 specifically references the misdemeanor sexual assault statute.
My memory is that it specifically references 632 and certain statutes that I believe include it, yeah.
May I approach the witness, Judge?
Yes.
Showing you a copy of RSA 632A. I'm just going to ask that you take a look specifically at provision 4.
I've read it.
The call to that statute says it is a misdemeanor in Section 4, correct?
Yes.
So fair to say that 632A4 is a misdemeanor sexual assault statute,
Yes.
the statute under which Owen was charged
Correct.
and ultimately convicted,
Yes.
and which is referenced in 649B4.
I think the statute is referenced in 649. Yes, I believe so.
So fair to say if a statute is referenced in another statute, the whole statute is referenced?
Yes.
Upon what basis did you make the statement that we just discussed in paragraph 4?
Paragraph 4.
I'm sorry, paragraph 8.
What we were asking His Honor to do was to step back and well, actually, the language of 649 applies to misdemeanor sexual assault. Wasn't our contention that it didn't. What we were asking His Honor to do, at least with our first argument, was to step back and look at the overall statutory scheme to show that this was essentially an absurd result that was inconsistent with the overall statutory scheme, which our argument was that His Honor had the discretion to do. Again, not looking just at 649 and not looking just at 632, but looking at the entire scheme. That was our argument.
You could have made that argument pre-trial.
I suppose.
And you could have made it at halftime.
Halftime?
I'm sorry. When you filed the motion for directed verdict on the prefect charge, you could have made it then.
Could have.
But you waited until Owen had been convicted.
We filed the motion after he was convicted, yes.
So now you agree that Owen could have been found not guilty on all the sexual assault charges, misdemeanor and felony, and still have been found guilty of the computer charge.
Under the law, yes, although I think practically that was probably unlikely, but yes, that's true.
So the increase in punishment between the misdemeanor sex assault and the commuter offense would make no difference if he had only been convicted of the computer charge.
Make no difference. I'm not sure I understand the question.
Sure. If you go back to your pleading, paragraph 9, the dramatic increase in punishment, particularly the mandatory lifetime sex offender registration, is so wildly disproportionate to the crimes of which the defendant stands against cruel and unusual punishment. So the increase in punishment between the misdemeanor sexual assault and the computer offense would make no difference, and there would be no Eighth Amendment argument if he had only been convicted of the computer charge.
I think we still could have made an argument.
Well, how would there have been an increase in punishment for the single statute or conviction on the computer charge?
Our argument was that, are you asking about the Eighth Amendment argument, or are you asking about the statutory argument?
I'm asking about the Eighth Amendment argument.
Our argument was that under the circumstances and facts of this case, it was cruel and unusual punishment to require lifetime sex offender registration for someone who had only been convicted of misdemeanor sexual assault. So in your hypothetical, the argument would be, and again, it would depend on the facts of that particular circumstance, but the argument would be that it's cruel and unusual punishment to impose this type of penalty on someone who essentially would be challenging the statute, I guess, almost on its face in that circumstance. But the argument would be that it's cruel and unusual punishment to require lifetime sex offender registration for someone who used a computer to commit what is a misdemeanor that in and of itself doesn't require sex offender registration.
But what if Owen wasn't convicted of a misdemeanor?
If he had only been convicted of the computer charge?
Because that was foreseeable. Your goal was that he be found not guilty of everything, but you agree that there were a number of permutations.
Of course.
So how would that argument have stood?
I think it would have been similar to the argument I just summarized for you. I mean, arguably it would have been stronger, but again, it's an argument we made to the court.
And an argument you could have made earlier than you did.
We could have, yes.
And if you had done that, it would not have been deemed untimely.
Presumably.
So we've talked about a couple of cases, and you've indicated that you have no recollection. Do you have any recollection of State v. McMillan?
Again, I think I remember the name. Sounds familiar, but I don't, obviously it was over a year ago.
State v. Jennings?
I don't have a specific recollection of the cases.
State v. Keiko?
That sounds familiar. Sort of a distinctive name. I believe I've encountered that case.
State v. Lacasse?
I don't know.
You have no recollection of any of these cases?
They sound vaguely familiar, but I haven't dealt with this issue since then, so I can't tell you specifically that I looked at those cases. If a case was cited either in our pleadings or the state's pleadings, then I can say with a high level of certainty that I looked at them, or at least that someone else in my office did. Excuse me.
Judge, may I approach the witness?
Yes.
Thank you. Show you two documents. The first has been marked as a full exhibit, number 12. And the second is exhibit 33. I have number 12 as ID. You have number 12 as ID? Well, I apologize. Apparently number 12 has been marked for ID. That's okay.
Can I look at it?
And number 33, which has also been marked for ID. Judge, we had agreed that these would be full exhibits. I would ask that the court permit striking the ID and that they be marked as full exhibits. Do you recognize this document?
Yes, I do.
Let's start with number 12. That's the notice of appeal that your office drafted.
Yes.
If you look at page 3 of that of that notice, there are 3 issues that you raised. Number 1, whether the trial court erred in denying the defendant's post-trial motion to set aside the jury's verdict of guilty on the charge of use of computer services prohibited. Number 2, whether the trial court erred in limiting the scope of cross-examination of a witness for the state on an issue affecting his credibility. And number 3, whether trial counsel for the defendant was ineffective by not objecting to the court's jury instruction on the charge of certain use of computer services.
That's what it says, yes.
Did you draft this?
I think I did. I think I had input from other folks, but yeah, I think I wrote it.
Okay. And there's no dispute that your office drafted this document?
I don't think so. I remember I did a draft, which I don't think was ultimately filed. I believe this is it.
I would refer you to document number 33. If you look at the heading on that top, it indicates Owen Labrie, Owen, post-conviction matters, writ of mandamus, J.W. Carney's file, pleadings.
Mm-hmm.
And further down, so I think that's fair to say that this is a screenshot of your office's file.
That's what it looks like.
Okay.
The file, the file path would have been different on our computer, but yeah, that's what it looks like.
And the second item down is mandatory notice of appeal.
Yep.
And the date that document was modified is 10/28/2015.
That's what it says, yes.
You raised in your own draft of the notice of appeal that you were ineffective in the jury instructions.
We raised it as a possible issue that would be, we listed it as a possible issue on appeal, yes.
Why?
Because Judge Smuckler had found that our motion was untimely, and we are aware that when that happens, it could potentially be an issue on appeal.
So we discussed that one of the things that Attorney Rancourt would be handling were the jury instructions. Do you recall that conversation yesterday?
I recall the conversation.
And I believe what you said is we had decided that she would be handling jury instructions. Do you recall that?
I don't know if I use those exact words. It was that morning. Well, I guess it depends what you mean by handled.
I guess I want to focus on the word we. Who was we?
My understanding before the trial was that she was going to be involved. I mean, she was going to be involved to the extent that we needed her, but there were specific issues that we were certainly going to need her for, and jury instructions and her input on jury instructions was one of them. In terms of her actually being the sort of lead attorney at the charge conference, that was decided that morning, sort of on the spot, sort of unexceptionally. I mean, there was no real back and forth. So I guess that's why I asked. I wasn't sure if you meant handle jury instructions generally or handle the actual charge conference.
When was that decision made that she would be the one handling And I'm not committing you to the term handling jury instructions, but for purposes of our conversation, when was the decision made that Attorney Rancourt would be handling jury instructions?
Do you mean the charge conference or jury instructions generally?
Well, what you had said yesterday was that she would be handling jury instructions.
That she would be available to us and that would be one of the matters that we'd be consulting with her.
Did you discuss that with her specifically?
I don't know if I did. I think Attorney Carney might have.
Was that decided after or before you entered your appearance on July 31?
I think it probably would have been in that general time frame. The week when that was all happening, I know that Attorney Carney had spoken to her. He had spoken to Owen to make sure that he was comfortable with the situation. I don't believe I was a party to those phone calls. But my understanding, based on Attorney Carney, was that part of the, I guess, arrangement was that Attorney Rancourt would help out with certain, I guess, sort of state-specific tasks, if you want to call it that, like jury selection, that she would be available for, input into jury instruction. So that was my understanding, I think, from about that time, the last week of July.
And do you know if that was decided before or after you filed to excuse her from trial and not require her presence?
I don't know. I don't know. I'd be speculating.
I apologize. Please continue.
I was just going to say I'd be speculating, but so I don't know. I know her and Jay spoke about that issue, and I know he spoke to Owen. But I don't think I was a party to those phone conversations, so I can't speculate. I know that Jay Carney told me that was his expectation.
You indicated yesterday that Attorney Carney had been unimpressed with what Attorney Rancourt was bringing to the table.
He had made those statements to me.
Clearly not so unimpressed with her that he was concerned about her handling the jury conference.
He was in agreement with her handling the conference.
An agreement? Well, you proposed it. You and Attorney Carney proposed that she handle that conference.
I think it was Attorney Carney. I don't think it was me, but I'm not sure.
Okay. So she didn't ask or offer to handle that conference?
No, my recollection is we were discussing jury instructions, sort of just discussing what points we wanted to make. I think that Attorney Carney sort of thought she had a good handle on it and said, Jay, would you like to, Jay Rancourt,
sure.
Do you want to handle the charge conference? And my memory is she said, fine. I mean, like I said, it was pretty unexceptional.
Yesterday, we also reviewed the email that you had sent to Jay about, Attorney Rancourt about the jury instructions. You recall that?
Yes.
Judge, may I return to the witness, please?
Yes.
May I just have a refill of the water, please? I'm sorry. Yeah, this. I'm committed to this cup.
You're committed to it.
Thank you. Thank you very much.
You're welcome. And Judge, I should note for the record, Attorney Ruffle and I realized yesterday afternoon that this exhibit did not contain a page that we thought it originally had. So by agreement, we have modified the exhibit to include that additional page.
Okay.
So Attorney Zagaduri, I'm showing you what has been marked as Exhibit 29. Can you take a look at that for me, please?
Yes.
I would draw your attention to the second page.
The email?
Yes.
Yes.
So I'm sorry, the original email that you sent to Jay was at 8:39 p.m., correct?
Yes. I don't know if there were any emails before that, but I don't think so.
Okay. In your response to that email, her response to that email was sent back at 9:17 p.m.
Yes.
So some simple math says that was a very brief time.
Yep. Yes.
And in her response, she indicates, I've done a quick review. Initial thoughts are that his use of computer instruction requires penetration. I don't think that's necessary, but probably helps us, so I leave it alone.
Yes, that's correct.
Okay. So I want to focus on the language quick review.
Mm-hmm.
When you appeared the next morning, Attorney Rancourt had still not been provided with a full copy of the jury instructions.
I hadn't emailed them to her. Whether I gave her a copy that morning or whether she asked, I don't know.
And the night before was the first time that she had seen the jury instructions.
I believe so, yes.
But it had been previously decided that she would handle the jury instructions.
Yes, by handle, that she would be involved in the thought process, the deliberation, or yes, that she'd be available to advise us and to discuss the jury instructions.
Fair to say that in your email to her, there's nothing that makes it clear that you're going to be relying on her.
That's correct.
And there's certainly nothing in her response to you 20 minutes later that says that she understands that you're relying on her.
That is correct.
In fact, I would suggest that her email response to you indicates, in addition to the fact that it took her approximately 20 minutes to review jury instructions for a sexual assault trial, that she probably had not done a thorough review of the jury instructions.
Well, she said they were her initial thoughts. That's correct.
But you still thought it was wise and effective to have her handle the conference the next morning.
I didn't have a problem with it. She clearly had a grasp on the material. Her thoughts, she had read them that morning. Obviously, I don't know when she woke up and when she looked at them, but when we met in that hallway or in that conference room, we were discussing the jury instructions for some time. She had a very good handle on them. When Attorney Carney proposed it, I didn't have a problem with it, and neither did Attorney Rancourt.
She read them that morning.
I don't know.
I think that's what you said. You believed she had read
I
them?
believe she had, yes.
You had excused her from trial, correct?
I mean, the trial team had, I guess, yeah. I mean, it wasn't my... Yes. I mean...
She was not...
When you say you, I don't know if you mean me individually or the trial team, but yes, she had been excused from the trial.
You are the trial team. You're part of the trial team.
Yeah.
So when I speak about you and the trial team, that's you.
I guess it depends on the context. Yeah.
Well, you're responsible for the decisions of the trial team.
Yeah, I would agree with that.
So the trial team had excused her from trial.
The court had excused her based on the trial team's, or the defendant's motion, but yes.
To be clear, you had written a motion to the court saying, excuse her, we don't need her here.
I mean, I think that's sort of a glib summary, but yeah, that's the basic idea.
You don't know what days she was present in court.
I don't remember specific days. I mean, I remember specific times when she was, but I can't tell you every day she was here.
You don't know what she saw?
No.
You don't know what witnesses she viewed on the stand?
That's correct.
You don't know if she saw any of the testimony, to the extent there was any, about the computer charge?
I mean, now, again, a year and a half later, I don't. I mean, at the time, I had a much fresher memory, but I don't know.
Is it a good practice to have an attorney who you are not sure has viewed the entire trial and is aware of the entire file handle jury instructions for a case of this nature?
Under those circumstances, she clearly understood the law. She was very articulate about the law. It was a purely legal conference, and I thought she was fully capable of handling it, and I assume she did too, because she didn't hesitate. She didn't argue. She gladly, well, I shouldn't say gladly, I don't know what she was thinking, but there was absolutely no resistance or reluctance that she expressed. And she, in my view, she absolutely understood the legal issues that were in play with respect to the jury instructions.
Okay, but let's be clear. Handling jury instructions is more about having a legal grasp on the instructions themselves, correct?
Yeah, I would agree with that.
For a jury to be effectively instructed, the attorney drafting the instructions has to know what evidence came in at trial.
I think that's helpful.
You think it's helpful?
Of course.
And in fact, the information that Jay gave you was incorrect.
Jay Rancourt?
Yes.
Which information?
Well, one of the instructions that she provided you talks about penetration being required.
I didn't believe that was incorrect. I
Did
actually
you think that was incorrect?
I did not. And when I looked at it, I thought it was correct at the time.
Did you research it?
I believe I did, but I don't have specific memory. But I believe I came to the same conclusion.
You believe you did?
I do.
How much time did you spend that night going over the jury instructions?
I don't know.
You don't know.
I know I sent her an email at 10 p.m., but I don't know how much time I spent.
On direct, you also said that after you entered your appearance, you were gone for a chunk of time. Is that accurate?
I was out of state from, I'd say August 5th, I believe, until August 15th, roughly.
15th?
Mhm.
So 2 days before jury selection, you were out of state?
Yep, I got back late Saturday night. That's correct.
So you entered your appearance approximately July 31,
That is correct.
and you left state on August 5, so 6 days later,
That is correct.
and returned 2 days before jury selection.
That's correct.
And jury selection started on a Monday.
Correct.
On direct, Attorney Ruffle asked you about opening the door to prior bad acts evidence. Do you remember that conversation?
Yes.
And you stated at that point that there were other allegations made against Owen?
That's my memory, yes.
Okay, to be clear, no one else had accused Owen of forcible rape.
I believe that's correct.
Okay. There had been no other reports to the police department accusing him of rape.
I think that's correct.
No one had claimed that they had had anything other than consensual sexual contact of any nature with Owen.
That's not my memory.
That's not your memory?
I guess it depends on, I guess, how you sort of classify consensual sexual contact.
No one said that he forced them to do anything. I'm not speaking about Chessie. I'm
No, I
speaking
understand
about
that.
additional allegations that you raised yesterday.
I don't remember the specifics, but I do remember that, well, my memory is that there was an allegation of, I think, biting or something to that effect during a sexual encounter.
Okay, that would be the Wells?
I believe so.
Okay.
And I would consider that non-consensual sexual contact if that occurred.
Well, do you remember that Elizabeth Wells also told the police that that was consensual?
My memory is that the sexual sort of encounter in general was consensual, but that the biting was, I don't remember the language she used, but that it was, I'm not using her language, but that it was concerning or unusual. That's my memory.
But she
And
stated ultimately that that was a consensual encounter.
Like I said, that she had consensually fooled around with him, for lack of a better word, but that the biting was not consensual or not something she expected.
She never reported that to the police
I don't know.
in the initial instance to pursue a charge of sexual assault.
I believe that you're correct with that.
So when you talk about other allegations, there were no other allegations of rape against Owen.
There were no reported allegations of rape. I believe that's correct, but I think there was another incident, but I don't remember the specifics.
Another incident being, I think it's a fair summary of the evidence or the discovery, and I think you said that you had a limited review of discovery. Is that accurate?
I don't know if I characterized it that way, but I reviewed the discovery that was relevant to my witnesses and sort of the most significant discovery in the case. But no, I didn't review every single page of discovery.
You didn't review every single page.
It was, no, I mean, there was tens of thousands of pages, or maybe not that many, but there was, social media discovery. It was Attorney Fullerton who went through most of that, or all of that, I believe.
And it would be hard to review that in 3 weeks.
It would be, yes.
Fair to say that there were reports, I think, of all the boys that were involved, including Owen, of other romantic encounters that they had had with girls on campus?
There were other reports of, romantic encounters, yes.
And you said on direct that Owen agreed with the trial decisions that you made,
Yes, that's correct.
that he agreed with your strategy.
He never expressed a disagreement, so yes, I believe he agreed with us at all times. He asked questions, as he should, but there was never a point where I thought he disagreed with what we were doing.
Did you review the jury instructions with him?
I don't think so.
Did you review with him that you were going to have Attorney Rancourt handle the jury charge?
I don't know.
You didn't even know that Attorney Rancourt was going to be present the following morning.
No, I was expecting. I'm not sure. My memory is that I was expecting to see her that morning, but I'm not sure.
When Owen retained Attorney Carney's firm, he was 18 years old. 19 years old. Correct?
Sounds correct.
He had just graduated high school.
He had graduated in May of 2014. He approached us in February of 2015.
So while legally an adult, he was a kid.
I would agree with that, although it's sort of a colloquial term.
And I think you made that argument in some of your pleadings.
Sure we did, yeah.
And he retained Attorney Carney's firm. He had no criminal experience. Owen didn't. Correct?
Like no criminal record?
He had no criminal record.
Other than this case, that's correct, yes.
He had not worked in the criminal justice system.
I believe that's correct.
You're saying that he agreed with the decisions that you, his attorneys, were making.
We talked about trial strategy with him. We kept him informed of what we were doing, and he always seemed amenable to it. I'm not sure how else to phrase it.
You went to law school, you indicated. You graduated from BU.
Yes,
Getting a law degree is not an easy task. Fair to say?
I would agree with that.
It's labor intensive.
Took some time, yeah.
Lots of reading.
Too much reading, yeah.
And it's fair to say that the bulk of your talent as an attorney, generally speaking, comes from practice in the courtroom.
Yes.
Practice that an 18-year-old kid wouldn't be able to assess. 19-year-old, I'm sorry.
I don't know if I generalize it like that.
Owen trusted you.
I believe he did. I hope he did.
He trusted you and Jay Carney.
I hope he did. I believe he did, yeah.
He trusted you to do what was best,
Yeah.
and that's why he hired you?
Yes, although, I mean, in fairness, he hired Jay Jay Carney. At least at first, the expectation was not that I'd be one of the trial attorneys, but yes, he hired the firm because I believe he trusted us, and yeah.
To advise him.
Of course.
To advise him about what was best.
Yes.
Because he wanted the best outcome for his case.
Of course.
He had to fundraise to pay your firm.
I believe that. Yes, that's correct.
And you think you were effective in representing him?
I believe we were.
I have nothing further right now, Judge.
Correct.
I just have a couple of questions that I'd like to review with you. Attorney Zagnori, in regard to the computer use charge, based on your understanding, do you believe that one computer can communicate with another computer without being online?
I say this reluctantly. I'm not a particularly tech-savvy person.
And I accept that.
I think online means connected to some type of network. That's what I think.
And did you base your assessment of the statute and the facts and circumstances of this case based on that understanding?
And I based it on the plain language of the statute, obviously based on my life experience, I guess. But yeah, I looked at the terms in the statute, I looked at their plain language and plain meaning, and I felt that they encompassed the accusations here.
Do you agree that the statute indicates online or internet?
Yes, I believe that's correct. Internet service or online service, I think, is the language, or bulletin board.
Attorney Malone had asked you quite a few questions about your motion to set aside the verdict. And you've mentioned that the court agreed with the state that that was an untimely motion brought before the court. Do you agree?
Do I agree that the court ruled that it was untimely?
Yes.
Yes.
Do you recall the order that Judge Smuckler issued in that case?
Generally, yes. He ruled that it was untimely, but then he said even if it were not untimely, he reached the merits and indicated that the court would have denied it on that basis as well.
May I approach you on that?
Yes.
Do you recognize this?
I believe that is Judge Smuckler's order denying the motion.
And I'm going to ask you to read directly from the court's motion in regard to your, and it begins, I believe, here.
That whole paragraph?
Yes.
Excuse me. The foregoing is not dispositive. The defendant is arguing that the evidence is not sufficient to support the jury's verdict under his construction of the statute. Even if an objection is not timely interposed, it could be plain error to maintain a conviction that lacks evidentiary support. See State v. Houghton. It's a slip opinion, October 14, 2015. Thus, the court will consider the merits of the defendant's motion.
And the judge actually does go on to consider the merits of your motion and to rule accordingly.
He did, yes.
Do you have any reason to believe that if these issues had been raised either prior to trial or during trial, that you would have prevailed on the arguments that you made post-trial?
Based on Judge Smuckler's opinion, it seems that the court was not moved by the merits of the motion.
And so the fact that this was filed post-trial actually doesn't show any prejudice to the defendant's case. Is that correct?
I would probably agree with that, although it's hard to say that sort of in a vacuum.
And again, we touched on this yesterday, and I only want to touch on it again briefly, but you testified yesterday that you did not rely entirely on J. Rancourt for the assessment of the jury instructions. Is that correct?
That is correct.
You did your own review and assessment of the jury instructions, and you were comfortable with them.
Yes, I believe that they were accurate.
And that was prior to going into the conference?
Yes, as I said, I was prepared to handle the charge conference that morning.
May I just have one moment, Your Honor?
Yes.
Attorney Malone has raised the issue regarding your strategy to try to keep 404B evidence from being admitted at trial. And I would just like to talk a little bit about that. We talked a little bit yesterday about what that 404B evidence might be.
Do you mind just reminding me some?
And that's exactly what I would like to do. Your Honor, if I may approach the witness.
Yes.
And for the court's purposes, I'm going to ask that this be marked as State's Exhibit Number 3 for ID. Your Honor, I have a copy for the court.
That's fine if it's the exhibit that was attached to your objection. Have it as well.
It is. It may be a. We gave you a portion of it. This may be a more complete version and it's not redacted, so it might be easier to read.
That's fine.
Trying to make it simple.
No, it's fine.
Attorney Zaganor, I'm going to
So stage 3 for identification.
give you what has been marked as State's Exhibit Number 3 for identification purposes, and I ask you to take a few minutes to review that to yourself.
All of it?
Yes.
Sure. Thank you.
Could you describe for the record what this exhibit is?
It's a police report or a police narrative describing an investigation into, well, describing police's interaction with a young woman named, can I say her name? Well, with a young woman. Her mother notified the police that she had heard some concerning things involving her daughter and Owen, and then police conducted an interview of the young woman, and she told them about an encounter she had had with Owen.
Now, you had stated in your interrogatory in response to raising the issue of selective prosecution or jury nullification that, and I'm reading from your interrogatory, more significantly, I was aware that other females had reported that Mr. Labrie had been unusually aggressive or physical during sexual encounters. My memory is that this evidence was excluded at trial. If we had presented evidence of selective prosecution at trial, it may have opened the door to these other acts, as the state could have argued that it considered these incidents in bringing charges against Mr. Labrie. In regard to the exhibit that I have asked you to review, can you identify what 404B evidence, if any, may be contained in this that you were concerned about its possibility of being admissible at trial?
Primarily it would have been the young woman's first-hand account of her encounter with Owen, where she said that he had sucked on her lip, giving her a blister. I recall seeing the photos, which were somewhat gruesome, that he had sucked on her breasts to the point where it left bruises, that she had said that it hurt and was not okay, but that she let him keep doing it, and never really expressed that she wasn't enjoying it. She also mentioned that she was getting up to leave and he closed the door and sort of continued making out with her, although it's not clear if that was consensual or not. That's the overview. There's also references to other sort of reputational information, but I don't think that would likely to be coming in.
And I didn't expect you to comment on that, but you also raised the issue, isn't it correct, that EW actually did take a selfie of the blister on her lip, and the state had possession of that and was prepared to enter that at trial, if possible, as well?
I believe that's correct. I do remember seeing the photos myself. I assume we got them from the state.
So is this an example of the 404B evidence that you worked to keep out because you believed it would be damaging to the defendant?
Yes, that is something we very much wanted to keep out.
Your Honor, I would ask that the ID be stricken and it be marked as a full exhibit. Your Honor, may I place your witness?
Yes.
And the court as well. I have what I'm going to ask to be marked for ID, State's Exhibit number 4. I'm going to ask you to review this as well.
Thank you.
Thank you.
State's for ID.
Yep.
read it. Thank you.
And again, for the record, would you describe what this exhibit is that I've just handed to you?
It's a police narrative detailing an investigation into an incident, or a couple of incidents, I guess, between Owen and another young woman.
And is this an example of 404B evidence that you were concerned about at trial?
We very much wanted to keep this out at trial.
And explain to me what it was that you wanted to keep out at trial.
Again, there's reputational evidence, which I don't think would have come in, but more significantly, the young woman was interviewed by police, and she described I believe it was two sexual encounters with Owen. Again, some of the similar type of, I think she characterized it as aggressive conduct, which included hair pulling and lip biting. But more significantly, she described an incident, I believe during the first encounter, where Owen was digitally penetrating her, and at one point during the encounter she realized that both hands were on her thighs, but that it still felt as though he was penetrating her in a different way. We viewed that as extremely harmful evidence.
And can you elaborate on why you viewed that as extremely harmful?
Well, one, it was factually very similar to what was alleged by Ms. Prout, and also just in general, obviously, evidence that a client in a case like this is aggressive with other females is harmful and prejudicial.
Now, just to be clear, this individual reported a consensual contact with the defendant. Is that correct?
She described it as consensual, yes.
And this individual was not a minor at the time that this occurred. Is that your understanding?
I'm not sure. I thought she was a student at St. Paul's, so I just know she was a student at St. Paul's. I don't know her age.
If you were aware that she was a junior at the school at the time, would that weigh in?
She did say that. She described one of the experiences as being during her junior year.
And likely she would have been over the age of 16 as a possibility.
I would assume, yeah.
In terms of, and I ask you this in regard to the accusation of selective prosecution, it was suggested that you could have offered for evidence what other boys had done. But in your recollection, was there evidence that other boys had committed incidents similar to this?
I don't believe so, not that I can recall.
And in fact, do you recall that E.W. indicated in her statement that nothing had happened with Mr. Thompson?
I believe that's correct.
But that she had reported what we talked about previously with the defendant, that she felt violated when he sucked on her lip and caused the blister and sucked or bit her breasts, leaving bruises.
I think she used the term violated. Yeah.
And there is no evidence in this investigation that any other young man committed any act similar to that.
At this point, I don't recall any evidence of that nature.
And again, just to be clear, it was your strategy at trial that it was important to you to prevent the state from being able to enter this evidence.
This was probably the most important evidence for us to exclude, particularly this account.
And did you consider yourselves successful in preventing us from entering this evidence?
Yes, my memory is that we filed a motion in limine, which was allowed.
Thank you. I would ask at this time that the exhibit be marked, this ID be stricken and be marked as a full exhibit.
Without objection.
Granted.
Thank you.
Thank you. I have no further questions.
Any requests?
Very briefly, Direct Judge. Selective prosecution is a question of why others were not pursued, not why your client was pursued.
I think that's both part of the inquiry.
And Attorney Ruffle just questioned you about these two documents. And she said at the end of her questioning, and I'm going to paraphrase this, there was no evidence that other boys had engaged in this conduct.
That was her question, yes. And
Referring to the conduct in the two exhibits that you just reviewed.
I interpret it as, yes, I guess sexually aggressive conduct. Yeah, I would agree with that.
Okay. This conduct is not what Owen was charged with at trial.
Not those specific acts, no.
No. So whether other boys engaged in this conduct would not have been admissible to compare selective prosecution when that conduct is not what Owen was charged with.
I don't agree with that.
Do you know what propensity evidence is?
I do.
Are you familiar with Rule 404?
Yes, we don't call it that in Massachusetts, but yes, I think the standard is similar.
And you're familiar with Rule 403B?
Yes, unduly prejudicial?
Yeah,
Yes.
unfair prejudice and probative value and the
Mhm.
balancing test that the judge has to.
Correct.
Okay. How would this evidence have come in? How would this prior bad act evidence that I think you have clearly established was prejudicial to your client
Mhm.
have come in?
I think if you argue selective prosecution, the essence of a selective prosecution defense is that you're prosecuting him, not prosecuting other people because of either favoritism for those folks or, I guess,